Good afternoon, everybody. Thank you for joining us this afternoon for our second webinar of the day, held as part of our Governance and Philanthropy series. As some of you may know, the Pearl Initiative is the region's only non-profit, business-led organisation commissioned to promote corporate culture of accountability and transparency as a key driver of competitiveness across the private sector in the Gulf region. We hold events across the region and conduct research and publish thought leadership materials across the Gulf. But in light of the recent public health pandemic, unfortunately, our knowledge-sharing events in person have had to go on hold. However, we have continued to deliver these on webinars and online. You'll notice that we've already held quite a few webinars, and we've got quite an exciting agenda for upcoming for April and May as well. This is continuously being updated and evolved, so please do stay tuned, follow our social media channels. If you're on our mailing list, you will receive the invitations for these events. Also, if you don't get the opportunity to attend these live, post the webinars, they will be uploaded for on-demand viewing on our YouTube channel. So please do follow up with those and visit those when you can. As I mentioned, today's webinar is being held as part of our Governance and Philanthropy program, which was developed in 2017 to build standards and best practices for giving across the Gulf region. The scope of the program has grown year on year, and today we're focusing on the various giving vehicles used across the region, most notably the Waqf. David will be leading a discussion on the basic principles of endowment, Awqaf, and the framework required to govern this vehicle to ensure its sustainability. More specifically, David's presentation will delve into the following key topics: the concept and origin of a Waqf, underlining the principles of sound Waqf management, and the values and concepts that underpin governance frameworks for Awqaf. Also, we'll be touching upon risk management and good governance based on international best practices. It is intended that this will be an interactive discussion, so you will have the opportunity to ask questions. I believe you can see a button to submit, type in questions and submit to David, and David can access those and see them as they come through. He'll likely answer them throughout the presentation or at the end, but we hope to address all of your questions. As always, it's a pleasure to collaborate with David. We've worked with David on a few initiatives in relation to our Governance and Philanthropy program, and this webinar is a follow-up from a roundtable that we held in 2019 in October, late October, around Waqf and the DIFC, Waqf and Foundation Law, sorry. So thank you, David, for your ongoing support and commitment to our mission and vision. We really appreciate that. So without further ado, I would like to introduce you to our subject matter expert, David Russell, QC, who will be sharing his insights on the governance of Awqaf. Before I hand over to David, I'll just give a quick introduction on his background and biography, give you context to the discussion. David commenced his legal practice in 1974 and is admitted to practice in Australia, England and Wales, Lincoln's Inn, the courts of the Dubai International Financial Centre, the DIFC, New York as a legal consultant, the Singapore International Commercial Court, New Zealand and Papua New Guinea. He has acted for Commonwealth and state governments as well as individuals and corporations, and was appointed as Queen's Counsel in 1986. He is the co-editor of the Oxford University Press Journal, Trusts and Trustees, and in 2012 he was appointed a member of the Order of Australia for, among other things, service to taxation law and legal education. In 2017 and 2018, he was recognized by Legal Week and the American Lawyer as part of the Private Client Global Elite. And in 2016, he chaired the DIFC's Wealth Management Review Working Group. So I urge you all to take advantage of his wealth of knowledge and expertise, and hope you get some insights to take away from today's session. David, over to you. Thank you so much.
Right, well, thank you very much. And it's a great, can I just reciprocate what has been said? It's a great pleasure to work with the Pearl Foundation in relation to this overall educational program. The tradition of giving, both in terms of giving for families and giving for charity, is a long and honourable tradition in this part of the world. But one of the problems historically has been the management of such endowments when they're established. And the Pearl Initiative has been particularly focused on improving governance and ensuring that ultimately the wishes of the person who makes the property available are respected and given effect, because that ultimately is what purpose of making an endowment is. And if having given property away, it's then not properly managed, there's a total defeat of the purposes of the person who's made the generous gift in the first place. So what the Pearl Initiative is doing, both in relation to governance of Awqaf, but more generally in relation to corporate governance, is a very important part of the development of this part of the world. And for myself, it's a very great pleasure to be part of it, and hope that it will progress. What I'm going to do, if I can, in the time available, is first of all talk about the concept of a trust. Now, you might ask me, why am I starting with trusts? The answer is that the English concept of a trust, although, as we'll see, very possibly even developed from Awqaf, but certainly has very many features in common with it. But because of the common law tradition, the sorts of issues that arise end up in front of courts. So we have a body of law and tradition and principle which is applicable equally to Awqaf, but because there isn't that body of learning supporting the detailed management of Awqaf, it's a useful place to start. But what I want to get across, perhaps more than anything else, is we are not here talking about some implant that comes from the West. We're talking about something that goes back to the time of the Prophet himself, and indeed, on one view of Islamic history, the first trustee was the Prophet himself. So what I'm going to do, first of all, is talk about the concept of the trust, then how that relates to the Islamic analogue, and then how the civil law world treats the same concept through foundations. That will take us about halfway through the lecture, at which point I'm then going to turn to issues of wealth management and Sharia principles, because many of the people who endow property in this part of the world will be wanting to comply with their Sharia obligations. Also looking at how it applies in the context of family wealth management. Finally, I'll give you some suggestions as to further reading, and I'll be happy to answer questions. Now, the point has already been made that I'm happy to take questions during the presentation. I think when I did a previous contribution for the Pearl Initiative, I made the point that in my life as a barrister, I'm used to being interrupted by experts. They're called judges. So it won't disturb me over much if somebody wishes to ask a question. And often if you ask a question during as I'm going through, the answer will be more relevant and it will fit in better with the overall program. And as you can see, you do that by using the chat box, which is on the right-hand side of the screen that you have in front of you. I just have to move this forward. I see. Yes. And as you say, the tradition of giving in this part of the world is a very ancient tradition. This is a statement from, as I say, the Prophet himself, that the things that a person can do in his lifetime all come to an end when he dies, but what he can do is by making a charitable gift or knowledge or having pious offspring, he has a future that goes with himself into the new world. And then the other issue is the extent to which one can make charitable gifts for one's family, or the extent to which the giving is limited to third parties. And that is something which has been addressed in both Islamic jurisprudence and perhaps more importantly in local laws in the United Arab Emirates. I should say that we have now 3 sets of laws in the United Arab Emirates that deal with Islamic endowments. We also have provisions for endowment under laws in Bahrain, in Qatar, but nowhere is there a specific, apart from the United Arab Emirates, are there specific laws that address Awqaf as such. And that, of course, is an important part of what we're discussing. And as you can see, the Kingdom is now looking at the regulation of Awqaf. There is, in fact, the Minister for Islamic Affairs is also responsible for endowments. And you can see the role, well, the history and tradition of endowments in the context of the Kingdom, where the holy city of Mecca is considered the greatest of all the endowments and gifts. And once again, it is an act of worship, and it's also a message which is intended to inspire. If we look to the concept of the trust, the starting point is that in English law, the owner of property is something that's established by whether or not you have in your hands a document called the title deed. Those of you who've played the game of Monopoly will know what that means. You have a document that says you own something. And traditionally in England, before the days of registers and the like, ownership of property was established by physical possession of the title deed. And that physical possession of the document gave you all of the rights of the owner. Come the, particularly initially in the time of the Crusades, but then later in similar circumstances where people went off to war, you had a situation where under English law, a husband and wife were legally the same person, but the husband had all the power. So he goes off to war. What happens with his property? He obviously can't take the title deed with him. There's no point in leaving it with his wife. So what had to happen was that the documents would actually be handed over to somebody else. And the question then became, what happened when he came back? Or in the meantime, what happened to his wife and family? Because he would obviously only give the documents to somebody who promised to look after them and look after his family while he was away. And so the English courts, and in particular the courts of the Lord Chancellor, developed the concept that if that sort of thing happened, you weren't allowed to treat yourself as the absolute owner of the property. You had to honour the obligations which you had taken on in terms of looking after the property, and more to the point, looking after the people to whom it was attached. So that you had on the one hand a formal legal instrument which says, or document which says, I own the property. But you had separately from that a court saying to the person who owned the property that they owned it subject to certain obligations which the court would enforce. That differs from the civil law approach, because the civil law approach is basically that once you have established title in the form of an actual legal right, you can't create new rights by agreement between yourselves. You have to deal with the various types of rights that are permissible under the civil law, and you have to do what is necessary to document them. So the trust is quite different from a civil law transaction, where what you have to do is look for some form of right which you can create, which you then seek to enforce. If we go now to what we know about trusts, I've said enough, I think, to explain how a trust works. The first point is it's not a contract. A contract is an arrangement between two people or more people who, by voluntary agreement, decide that as between themselves there will be different obligations to the obligations which the law imposes. In the case of a contract for purchase and sale of a property, I agree to pay you a certain amount of money on a certain date. You agree to give me the property on that date in return for the money. Nobody else is involved in the arrangement, but as between us, it creates enforceable rights. A trust, of course, creates benefits or rights in people who aren't parties to the contract. They would be the beneficiaries of the trust, so that a trust is not a contract, nor is it an agency in a situation where the trustee simply has to do what the owner wants. An agent has really no discretion of his own or no rights of his own in relation to the property. He simply has to do what the owner tells him. If we go back to the concept of the trust, often the owner wasn't there, and increasingly now trusts are used as part of dispositions that people make when they die. So the person who has entrusted the property to a trustee isn't around to act as the principal. So it's not an agency arrangement either. The trustee has independent discretion what to do with the property, subject to the terms of the trust deed. Nor is it a company, because a company is a legal entity in its own right, whereas a trust is an individual or a company which holds property subject to obligations, but it is a personal obligation, not a legal entity which has existence in its own right. So if we come back to the overview that I was talking about, a trust is a relationship, it's not an entity. And the question is whether there's a court that will supervise the trustee's performance of the terms of the trust and enforce its judgments. In English law, we use the expression equity acts in personam. In other words, the court will tell a trustee what to do, and if the trustee doesn't do it, the trustee can be punished for breach of that obligation. And it follows that in principle, the location of the trust assets is irrelevant. If a trustee is within the jurisdiction of the court, the fact that the property might be outside the jurisdiction of the court doesn't matter. The trustee can still be told what to do. There are risks in a non-trust jurisdiction because the trust assets could be applied to satisfy the trustee's private debt, but that is not going to happen if you have a standalone trustee. And English law then provides for various categories of trusts. I've been talking about express trusts, but we also have resulting trusts. That happens if somebody tries to establish a trust and doesn't manage to do it properly. In such a situation, you can't let the trustee just keep the property. So what is said is you have a resulting trust for the set law. The trustee ultimately has to give the property back. And finally, there's a constructive trust, which is a judicial remedy and arises if the court is of the view that a person ought to be required to hold property on trust even though they haven't agreed to, because of the circumstances in which they hold it. The court will say, well, the profits of your ownership of the property really belong to somebody else. And we have similar concepts in civil law countries. We have the fiducie in France, the fidei commissii in Italy. We have statutory trust laws in China, Taiwan, Switzerland, Liechtenstein, and Monaco. And there's also an international convention on the recognition of trusts, which has enabled trusts to be established in places like Italy. I'll come back to that. Now, the Islamic, this is where we come to the key topic of today's conversation. The Islamic equivalent of the trust is the Awqaf, or Awqaf, of course, is the plural. Waqf, if you are talking about it in the singular. Now, hang on. And, oh, that's foundations, hang on. We seem to have got this out of order. No, hang on, I've missed something. Sorry, I pressed the wrong button. My apologies. I've talked about, in the context of Awqaf, the historical precedent that, depending on how one views Islamic history, the first Waqf was actually one created by the Prophet himself. But you have concepts in relation to Awqaf which are very similar to those of what the English would call a trust. You have, in the first instance, a waqif. He's the person who gives the property away. He's called an endower in the UAE laws. He would be called a settlor in the context of an English trust, or a founder in the context of a foundation in the civil law sense. Then you've got the person to whom the property is given. He's normally called the mutawali, sometimes translated as administrator or manager. But he holds the property on the terms of the Waqf, and it's his obligation to comply with those terms. And finally, as always, you have to have somebody who will enforce these obligations. In Islamic jurisprudence, that is the Qadi, filling much the same role as a court would in the context of an English law trust or a civil law foundation. Now, one got to the point where a huge amount of property was held in Waqf because it was seen as a useful way to hold property. It was also seen as a useful way to avoid paying taxes on it. So around the 1870s, one had gotten to the point where something like 70% of the productive land in the Ottoman Empire was held in Awqaf. And it was said, at least by the government, that it wasn't well managed. So over time, the government passed rules and regulations which effectively transferred ownership of those properties to the central government. And that is an event that has never really been forgotten in this part of the world, because if you ask people who want to use structures to preserve their wealth or pass it on to the family, why don't they use a Waqf, given that it's available? The response always comes back to that history and more recent history. For example, in Egypt, family Awqaf were all nationalised in the 1950s. And there's also a great deal of pressure on Awqaf in India. So, and you can point to commonly similar examples in English history, particularly in relation to the time of the Tudors, when church properties were taken over by the state. So it's not a process that is unique in this part of the world. And of course, because Awqaf were established long before trusts, there is a lot of history which suggests that the English actually discovered the concept of the trust through their interaction with this part of the world during the Crusades. And when we get to the end of the paper, you'll see an article which I'll give you the reference, in which such institutions, in which there's an analysis of the history which shows how the concept came to be adopted in a very similar way. So what is perhaps not shown is that the person who established the first recorded trust in England was aware of the Islamic jurisprudence. It wouldn't have been sensible for him to say that he was, even if that were the position, but it ended up with a very, very similar concept. But as a matter of grammar, Waqf really means detention. The idea is that the ownership of the property is separated from the person, and the gift of the property or the usufruct, either presently or in the future, is to some charitable purpose. Now, now I see we have a question. Hang on, let's see. The question, in the traditional form of Waqf, is property would be the Wafi's responsibilities. Can you give us an example? What would be the Wali's responsibilities? I think you mean the Mutawali. The short answer is that he has to do exactly what a trustee would do in the context of an English trust. In other words, he is responsible for the administration of the property. His obligation is to preserve the property. One area in which a Waqf is somewhat different from an English trust is that there is a presumption that the property should be held, the same property should be held and not sold and perhaps turned into more profitable property, but it has to be managed and protected. And then the instructions will have been given by the Waqif as to what to do with the income from the property. Now, that could be to give it to specified charities, to maintain a particular religious institution like a madrasa or a mosque, or it could be to give it to the family of the Waqif. It will all be determined by the terms of the Waqf, and those obligations will be enforced by the court, or in the context of the Awqaf laws in the United Arab Emirates, by government officials. And here we are again, is yet another expression of what a Waqf is, the appropriation of a particular thing. So we have the subject of the Waqf, that the appropriator's right in it shall continue, and the advantage of it shall go to some charitable objects, or it is the detention of a specific thing in the ownership of the Waqif or appropriator, and the devoting or appropriating of its profits or usufruct in charity to the poor. So that's a situation where only the income is applied for the purposes of the Waqf, as opposed to the underlying property. Now, that has moved on, and as we'll see in the context of the standard Waqf law, and indeed in English trust law or foundation law, the property is actually transferred to the trustee or the mutawali in the context of the Awqaf laws of the United Arab Emirates, and indeed traditional Islamic jurisprudence. The view is taken that a Waqf has legal personality in its own right, and in that respect it differs from a trust. In a sense, in traditional jurisprudence, the owner is now seen to be Allah, but the management through the Board of Management or the Mutawali, again, traditionally they were regarded as irrevocable. They were regarded as perpetual. In other words, they went on forever. The property was inalienable. In other words, it wasn't up to the Mutawali to say, well, this particular property isn't particularly valuable, we'll get more income for the family or for the charity involved by selling it and investing in something else. And as I say, historically, the requirement was of a charitable intent, although some Islamic schools of thought included family support in that. And that is certainly the view that's taken in each of the UAE jurisdictions. As I say, we don't yet have Awqaf laws in the kingdom, although it's understood they're on their way. Certainly in Bahrain, there is an onshore trust law which achieves much the same objective. And over time, we can expect this perhaps to be more formalised elsewhere. I mean, in terms of what has come into existence legally to date, we have the Awqaf law in Sharjah, the endowments law in Dubai and the UAE. Actually, in each case, the Arabic term that's used, because they're the official English translations, the Arabic terms in each case is Awqaf. And finally, there's the royal decree for the establishment of the Saudi Awqaf Authority. The intention is that that authority will proclaim regulations relating to the management of Awqaf. That has yet to happen, but given that the decree now goes back about 3 years, one might expect that there will be some action in that area before too long. If one looks at what's possible in the UAE, and one might expect that these laws will become a basis for similar laws in other jurisdictions. First of all, anything can be the subject of a Waqf. There was a debate for some time about whether or not you could give money as opposed to give physical property, but it's now clear under each of those laws that anything, including money, can be the subject of a Waqf. In both the Dubai law and the national law, it's permissible to give away all of your property. In Sharjah, you can only give away a third of it, which of course reflects the share of property that's freely disposable by a testator in the context of his death. All such Awqaf have legal personality, so in other words, they're more like a foundation than they are like a trust. They provide for a manager and administrator. There's express provision for family Awqaf so that you don't need to have any charitable intent other than looking after your family. They can be established forever or for a limited term. There are restrictions on dealing with assets. There's a capacity to go to the court or the administrator, the government administrator, to get permission to dispose of the assets, but it's a much more complicated process. And there are some differences in the laws across the Emirates. I've provided a schedule to the Pearl Initiative, which actually has a table comparing the various provisions of these laws, and I've also provided copies of the laws themselves to the Pearl Initiative. So if anyone would like a copy of those after the lecture, you'll be able to obtain that. One of the important things about legal certainty and the need for these laws, and perhaps something which really demonstrates the history of why Awqaf have become less popular in this part of the world than one might expect, are the observations of Ibn Khaldun in Muqaddimat. And it really expresses a principle that is pretty much fundamental, actually, to how any civilization can work, which really is that the foundation of any civilization is a regime of stable and secure property rights. If they are taken away regularly, people take the view that there's no point in building up property, or achieving anything, and the result is that civilization is damaged. And just briefly, because this is not particularly relevant, except that it gives you a view of how civil law jurisdictions handle the same sort of concepts. You'll see that a civil law foundation is established by somebody giving property, on this occasion, to an entity which is a body corporate in its own right. The best way to think of a civil law foundation is that it's a corporation that doesn't have, a company that doesn't have any shareholders. Depending on where they're established, you can set them up for a purpose. So in other words, you could promote education or some other worthwhile activity. You could support a religious activity or just charitable giving in the sense of looking after people who are poor, or in some countries you're permitted to have a private foundation which exists effectively in the same way as a family Waqf. In addition to civil law countries which permit foundations, they're available in common law countries increasingly. Those include, in this part of the world, the DIFC, the Abu Dhabi Global Market, and the Qatar Financial Centre. So we now ask the question, what would we do with any of the, so if we just go back to foundations, the key point from what I've said is that they share attributes with both a trust and a company. In some respects, you might say they're much closer to a Waqf than a trust is. In other respects, you would say that a trust and a Waqf have more in common, particularly because you've got an administrator with a duty to look after the property, whereas in the case of a company, the directors who have an obligation, but they have it to the company, not to the people who might benefit from the company, such as shareholders. But they do have a comparable outcome in the sense that the rights of the parties between themselves are determined in accordance with the governing law of the courts in the applicable country of residence. A foundation is much harder to move than a trust. A trust can be moved overnight. A Waqf is normally very hard to move, particularly if its property is a fixed piece of property and its existence depends on registration. And although this doesn't really have much implication in this part of the world, there's some uncertainty as to how you treat foundations, and for the same reason, Awqaf, when you get to a common law country, because most common law countries treat trusts and companies differently. Insofar as we know what will happen if it gets before a court, the better view is probably that you should regard a trust and regard a foundation as a company rather than a trust. Now, the most important thing is, what would you do with these things and why? Because after all, a huge amount of property here is held in family businesses and usually owned by the patriarch. But leaving things in the hands of patriarchs creates all sorts of problems, particularly if patriarchs die, which of course they always will sooner or later. The assumption that often is made in families is that everybody will continue to get on after the patriarch dies, and the patriarch is usually very confident of that. What he perhaps tends to be neglecting when he makes that assumption is that one of the reasons why people behave is that they know the patriarch is there and will bring them into line if they don't behave. But of course, when he's no longer there, there's no guarantee, or I should say he or she, there is no particular reason to assume that will continue. And we saw in the Wealth Management Review a whole series of arguments about the extent to which this sort of planning for family purposes was appropriate, having regard to Sharia obligations. And we saw no distinction between the obligations that a Muslim might have under Sharia and the appropriateness of proper planning. Just have another question. Another question's come in. What is the Sharia ruling on the use of the Waqf structure to avoid Sharia succession and inheritance rules? Well, we start off with, can I say in relation to that by definition, if you're giving money to a Waqf during your lifetime, you are necessarily have the result that you have less property to give away when you die. But the traditional view in Islam is that you are able to give away property during your lifetime so long as it's an unconditional gift. What you can't do is use these structures to circumvent your obligations under the Sharia inheritance rules. That principle finds its way into Article 361 of the Civil Transactions Code of the United Arab Emirates. And the question that always has to be asked is this a genuine gift during lifetime which is permitted, or are we simply trying, particularly towards the time of what's called a death illness, are we trying not to comply with the Sharia inheritance rules but avoid them in some way? Precisely how that can be resolved in a particular case is probably a matter for Sharia experts rather than me. And I would always advise somebody to obtain a Sharia opinion on that. But what's perfectly plain is that both at national level in the UAE and at least in two of the Emirates, including the one that's usually thought of as being particularly inclined to Islamic jurisprudence, very plainly they recognise that you can give your property away, be held in a Waqf for members of your family, but not necessarily in the same proportions as their inheritance proportions would be, or for other purposes, and not infringe Sharia obligations. So, I was talking briefly about why you might want to use these structures. Businesses nowadays are complicated, and the control of the business when somebody dies, if you simply leave the matter to the Sharia inheritance rules, the business may end up in the hands of people who don't have the necessary skills. You can have fights within the family. They can be over matters on which minds can reasonably differ. And if you think, for example, of a building that's left, it's very easy to see how some inheritors might think that the building should be continually upgraded, so it's good. It continues to be a building of outstanding status. Others might take the view you run it into the ground. Still others might take the view that it should be torn down and a new building constructed. Now, those are all quite reasonable matters on which minds can reasonably differ. But if you force people into a position where they have to agree before anything gets done, often you will find that things don't happen at all, or if they do, you get second-rate decision-making. And that is reflected in the statistics when we get to the third dot point. Something like 3% of Gulf family businesses make it to the third generation successfully. So actually having proper planning for business governance going forward is a matter of important national strategy in this part of the world. And again, that's one of the reasons why I think the activities of the Pearl Initiative in this area are so important to the region. quite apart from anything else, if you have a situation where people start off fighting over business issues within a family, you'll often find that leads to families fighting about other matters. And as I say, the failure of those businesses will have a terribly negative effect on the local economy. Again, to take some recent statistics, there's something like $1 trillion worth of assets that are going to change hands in this region in the next 10 years. And unless that process is managed efficiently, it has the capacity to do enormous damage to the region, because it's not just the owners of the business who will suffer, it's their employees, it's the people with whom they're in contractual relationships. If they own important infrastructure, there will be damage to the infrastructure. So it's really important that these things be gotten right. And the other point, and this gets back to a question I was asked earlier, that in the Wealth Management Review, it was pointed out to us, and I emphasise I am not a Sharia scholar, but what was said to us was that wealth preservation for the family is actually an obligation of a person who holds great wealth, because the responsible management of wealth is one of one's obligations as a responsible member of the community and as a responsible member of the family. Now, if we ask how these structures can be used in family wealth planning, and we look at what's available throughout the GCC, all of the GCC jurisdictions will allow you to set up companies of various types. It has to be said, for example, that the UAE commercial companies law is not a particularly modern law. It's in many ways more like an incorporated partnership. Trusts are available in the UAE in both the Abu Dhabi Global Market and the DIFC, in Bahrain and in the Qatar Financial Centre. The Bahrain trust law is particularly interesting because it's an onshore trust law. It applies to all assets within the Kingdom of Bahrain. Foundations are available in 2 UAE jurisdictions and in the Qatar Financial Centre. So we have the statutory Awqaf, to which I've referred, all in the UAE, but with Saudi Arabia about to follow. Now, the issues that confront family businesses here now, let's see, I have another question. Yes, waiting for figure or structure, yes. Hopefully you will see that you're about to get that, if I can go back to the paper. The problem with the inheritance laws, first of all, you end up with fragmentation of ownership and control. For example, strictly speaking, under Sharia, if you have 5 identical houses, all of identical value, and you have 5 children, each of whom is entitled to inherit equally, you cannot leave one house to each of 5 children. You have to leave 1/5 of 5 houses to each of the 5 children. So you end up with fragmentation of ownership, which is never really a good way to run anything. You end up with fragmented control, and once again, you can see in the context of a business where often, as we've just seen, for example, in the last month, every business in this country has had to rapidly make very complex decisions relating to its future. It doesn't matter whether it's a grocery shop or somebody who's providing a business that's now been ordered to be closed, or businesses that are allowed to operate under different arrangements. These all create a need for fast and effective decision making. Fragmented control is normally the last way to get that. Within companies and shareholders, you end up with factions and voting. If you've got equal voting rights under LLCs, which are the traditional form of voting of companies, you end up with the lowest common denominator decision making, because there's normally a requirement for unanimity. Statutory preemption rights often inhibit the optimum management of the business, and if you need to raise money, you often need to get government approvals. So, the existing structures in many ways are not particularly satisfactory, but the alternative, you ask the question, well, what happens if you don't corporatise? Well, you will get the inheritance processes I've referred to. You won't necessarily give the next generation of leaders a solid and stable platform. If you use sole establishments and branches, you end up with a situation that you have the sole and personal responsibility of the founder's entity. The property ownership gets splintered on inheritance. If you haven't got a company, then you have unlimited personal liability for civil claims. That's particularly important if you have investments that are going to the West. And you could have the potential for criminal liability as well in relation to safety issues and increasingly environmental issues. And this is a good example of how you have poor design in a business. You have a situation where assets can't readily be disposed of. You have a situation of unlimited personal liability in the hands of the founder, and therefore a lack of flexibility. And so you ask the question, why would you want to use a Waqf, a trust or a foundation? And ultimately your answers are these, that corporate structures are inherently inflexible. Family share ownership means that you'll get the worst consequences of fractional, although you'll avoid the worst consequences of fractional interest in the underlying property. You still have the potential for disputes and log jams when it comes to decision making. And it's very difficult to engraft a family governance structure onto a company. You would normally try to do that through a shareholder agreement, but the only people who are bound by a shareholder agreement are the signatories. So they work for a while, but as soon as somebody dies, they're not there. Whereas if you have a trust, a Waqf or a foundation at the top, you can build a family governance structure, and then that entity, or the trustees in the case of a trust, can give the necessary directions to the shareholder, to the company, so that once we've sorted out at Waqf, trust or foundation level what needs to happen, there's then a clear capacity to go ahead and implement it. So the idea is you would end up with something like this, and I mean the trust, foundation or Awqaf can be used interchangeably at this level, but you have holding companies below that and operating companies, so that the Waqf is really an ownership vehicle, and all of the action happens below that under direction, and then you can split up particular assets in a way that is commercially rational. I mean, obviously you would have separate companies for assets in different countries. You might well have companies or other ownership vehicles in respect of particular classes of assets within the one country. All of these things are possible if you do it under the framework of ownership through one of the vehicles I've been discussing. But if you're going to look at this, the question, particularly if you're advising a family, is a structure of this sort appropriate to the family needs? And there are a series of questions I think that have to be asked in that context. The first of all is, does the family understand the legal consequences of the structure? I mean, this is not something you go off to a lawyer and accountant for, get them to sign things up, put the documents in the bottom drawer and just keep carrying on as before. These transactions have legal consequences. They have to be recognised, and people have to be prepared to live with them. If they don't, then sooner or later they're going to end up into trouble. So everybody needs to understand what's involved, and they have to be prepared to live with them, even if at times it's inconvenient. And sometimes, particularly if you end up in a family dispute about inheritance, and one of the issues is whether or not these structures have been validly established, then everybody's got to be prepared to give evidence about what's happened, because ultimately a court will decide how they operate. And of course, unless it's very clear that there'll be scrupulous compliance with the legal structures that are created, you end up with the problem I'm about to discuss in the next slide, which is Sham. Because one of the arguments that can be put against these structures is that, in fact, although the legal documentation was brought into existence, it hasn't been, in fact, what people did. You could argue that the company or the foundation or the company or the foundation or the Waqf is simply a nominee for the original owner. You could argue that there's a motive of avoiding tax in a high-tax country, and it would be relevant in the Sharia context because to the extent that you haven't made an effective gift to the entity concerned, you then run into the Heber principle that the gift has to be absolute and accepted before it takes legal effect. Now that takes me to the end of the paper. I haven't got any more questions yet, I see. But I mentioned a couple of articles, in particular the one I mentioned about the history of Awqaf and how that history contributed to the development of the English law of trust. That's an important article and well worth reading for those of you who are trying to follow these matters. And one, I see I'm one of the co-authors, but it's a peer-reviewed paper on the same topic. That takes us to the end of the time. I think we have about 2 minutes left. If there are any further questions. First of all, I see that there were 3 questions. I've tried to answer them as we've gone along verbally. Well, the result is that the program says that they're unanswered, but I've tried to answer them. Any further questions or comments before we finish up? But we're now sitting with 2 minutes to go. As I say, more than happy to answer any questions if people have them. Probably shouldn't have. Always a problem when you leave time for questions. Sometimes, I mean, that could mean that I've answered everybody's questions. It could mean, of course, that nothing I've said has been clear enough to. Here we are, another question. In the beginning, you are focusing on the Abu Hanifa school instead of mentioning others. Why? That's simply because I have to say we were looking at the written material that was available at the time that I wrote the article that I've just referred you to. I'm familiar with the fact that it is the Hanbali school that is more relevant in the UAE, and I'm aware that there are 2 other schools of Sunni Islam as well as the Shia views. I think I picked those quotes because it seemed to me that they encapsulated the concept of the Awqaf or detention fairly well, and I thought that expressed the concept very well. But certainly it seems to me that if you look at the domestic, when I say the domestic, the UAE Awqaf laws, they are consistent with much the same sort of approach. So if I have picked quotes that are controversial having regard to other schools of Islam, then I'm very sorry for that. It certainly wasn't my intention to do so. That takes us, I think, to 4 o'clock, unless there's anything further that can be done or said. Certainly the last of the questions. Just checking with Sanjay if there's anything further I should say and do. Okay, thank you. That's it. Cheerio, everyone. Thanks a lot. And as I say, if you want anything further, I'm sure that our Pearl Initiative will be happy to pass on the material to you in due course. Thank you very much and goodbye.